Division bench item for orders 1, 2, and 3. PIL 60, PIL Sumoto 1, PIL Sumoto 2.
Mr. Nath, no difficulty in the officers attending today?
There is some. For 1 minute, they stopped, but from the court master information, the moment they have informed, they allowed to come. The Lordship has passed an order on 5/11, the last order.
Yes.
Pursuant to that order, we have received some instruction. In para number 4, Lordship's direction is there. That instruction we have placed. Lordship has directed that a report whether JJPs have been constituted in each and every district, whether it is properly constituted in accordance with the Juvenile Justice Care and Protection Act. It will be indicated that they are in the last date of tenure of various members. That list we have placed.
This
In that bunch, kindly
rules,
come to
this rules which you have drafted.
Malad.
You have consulted the other stakeholders also.
Yes. We have consulted, and in the instructions I will take to your Lordship. To the instructions below. Just below the covering letter, the response to we have indicated the response below. Copy of the draft rules and their policy we have handed over to the Honorable Court also. And as regard the JJBs,
How much more time is required by the state to
in the next
have this?
in the next cabinet it will be placed.
Okay. Placed.
It is we have stated in the instruction.
Okay. We appreciate the work done.
And the list is also there as regard the data of the JJBs.
Sir,
Now, how you propose to this fill up this lacuna and all? See, we are not in an adversarial litigation.
Correct.
This is the factual situation.
True.
Now, we also want, you should be also cautious that how to complete these deficiencies.
In
The timeline, how you are proposing, how this to be done complete. That's all.
in fact, the state level committee held its meeting on 11th of November and 12th of November. And for selection of the social workers in the instruction we have indicated.
I have seen that in the side in the remarks.
Remark. So in respect of that, if Lordship kindly comes to that data, in the second page of that data, in respect of Golaghat, Mazu and Biswanath, both the posts are vacant. That selection has been done. Remark column Lordship will find. In respect of Bajali and Tamulpur also, it is there. And in the meantime, a notification is there that Bajali and
that we have seen
Borpeta they will see. And in respect of some vacancies are there, we have indicated 1 vacancies and 2 vacancies somewhere it is there. Basically, Kachar and all these things, this selection process will take care of that.
Now, that's fine. That you are initiated the selection. Now, any timeline that we can complete that these vacancies will be 0.
Logic.
That is what we want. Any idea how you are proposing selection committee? Okay, fine. When can selection be completed? Thereafter, how much time it will take to issue appointments and all this?
Lordship, as I mentioned in the last hearing that the selection committee was not formed. So as soon as the committee was formed, we had placed for 9 districts in total. And the vacancies as per the DLSC recommendations, the SLC had selected it, and the minutes signed by Honorable Chairperson of the committee, Justice Rumi Fukan Baidu, it has been sent to the department for notification. So it is already.
So selection is, according to you,
According-
selection is over.
Over. So only the notification has to come out from the government side, as per the.
So then
final.
this remarks column will be all zero.
All zero subject to one issue, my lordship, if nobody resigns.
Okay, that is a different issue. That is
otherwise it will come.
that is an unknown territory. Somebody may resign, somebody may not join.
Yes.
But even after selection, somebody may not join. That is a different issue.
My
But
lordship,
can you complete this by next after Bihu vacation?
I think before that, the notification will come out, if it comes from the honorable ministers also, it has been sent. So the department will take care of the notification, my lordship. And we have already in the SLC committee, have already decided for the vacancies that are going to be coming up in the year of
That is a
2025.
better proposition. At least 6 months or 5
so
months
we'll
prior.
propose- we'll initiate the process right after Bihu, that is in the month of February. We'll start the initiation for advertisement and everything for filling up the JJP vacancies accordingly.
Okay, it is good to hear that you have a plan now.
Yes, we have a plan.
At least for future, you have a plan.
Lots of-
It is good. But there is another connected issue which has come up a few days back. It came to our notice. You see what is happening? The payment of honorarium to these social workers. Those are done in terms of our the High Court notification number 41 of 2016. Now that is creating some hurdle because every time these things are to be routed and then it goes, so the continuity of payments are not there. This is also an issue which you will have to take up, continuity of payment to the social workers. And the third thing is that in view of the pendency in few of the JJBs, I think the sitting will have to be increased. Because otherwise, now we have a limited sitting for the purpose of reimbursement of their honorarium as well as other costs involved. But in few of the JJBs, if we don't increase the sitting days, I think it'll have adverse effect on the matters which are pending before the JJBs. You'll have to, in your department, you'll have to take a call. We are not giving any direction right now, but we are just making a request to the department to see if the sitting in few of the JJBs where the pendency is very high can be rescheduled.
My lord,
Correct.
as you just mentioned that the sittings is as per on the basis of the pendency of the cases. So it can be done, I mean, till
No,
16,
but
17,
unless the government takes a decision, the issues of this honorarium and all comes. Few days back, we as a,
dates, specific dates.
because in the last week, we had issued a notification, we had allowed as a one-time lesser payment of the honorarium to Jorhat social workers. So this also takes up our time on the administrative side. A lot of times are taken, then we have to ask questions, and those replies are given because those are financial sanctions which it has to be conquered by us. So
I think we can look at the pendency, and if at the same time, that notification you just mentioned from the honorable court is also addresses the issue that wherever there is a pendency, it can be raised. I go to this. I go to areas. 15.
okay. Just hear the order.
Mala.
Lordship,
One
thing, Lordship.
was just we were closing for today. to
Lordship.
discuss regarding draft rules, then.
One more
this
thing,
report,
Lordship.
Then we come to the other issues.
And there is a third issue also, conditions of the JJBs, that is the third PIL. We'll take it, those matters we'll take it up on the next date.
In the third year. Lord.
Because if because these conditions, you had done an audit.
But they-
To take stock of the conditions, you have done the audit. We'll have to, is that report available?
Social audit.
Social audit.
Audit is going on, they will be submitting the report.
Okay.
So
So because-
University Law Department is conducting the audit, my lord.
Because as per that PIL, the conditions are in few of the homes are pathetic.
Lordship, apart from this lordship vacancy, lordship, the basic infrastructure of the JJB is also updated instruction is required, lordship.
One by
Yes,
one.
we'll take it up one by one. Let these things be over, because first priority was this draft rules.
Infrastructure after the,
Rules of
there is
Protocol
main,
Supreme Court.
main.
Because lordship,
Checking committee.
in Kamrup Metro, suppose lordship, there is no room for the principal magistrate and member also. lordship.
We are aware of it. But we are doing in phases. Otherwise, if we open up everything, there is another, everything gets clogged up. So we are trying to streamline everything.
Lordship.
First priority was this rules.
Appointment.
Rules.
Rules.
And these rules have come, child policies have
Right.
come. Once the policies are adopted, then these things will be a follow-up. Correct. But we open up everything. It'll be difficult for us to, because there are, you see, there are hundreds of orders passed till now. And at least there are more than 20 such directions. We have not been able to compile it. So last time, when Mr. Sharma had given us a compilation of 5 items, we are taking up those. It's become easier to take up the issues. So we are aware of those issues, but for the time being, we are taking up concentrating first on the draft rules, and other issues we will take it up on the next date. And you have any instructions about utilization of funds?
Well, if I'm allowed to just make a submission before going to that, but in our instruction, the child protection policy would be placed before the cabinet in the next sitting for approval. And the rules, subsequent to an order of the Honorable Apex Court, some modification incorporation has been done, and that is where we have already that is to be placed before the legislative, and then the process. This is also going on, this will be also done.
That you have stated where?
That we have stated, in paragraph. Kindly take our response,
Yes.
paragraph number 3. Paragraph number 3, Lordship, we have stated that
As
in the
regards
next.
para 5.
As regard para 5, that is the policy will be placed before the cabinet in the next approval,
Yes.
for next sitting for approval. As regard the draft rules, we have stated the next para. The Honorable Apex Court's decision, paragraph 44, that the requirement has been incorporated. This has been already incorporated. The response to next page.
And there's one more thing, since we have not read this, as per the child protection policy, I think you have taken into account the new Bharatiya Sakshi Adhiniyam and the requirement of under the BNSS.
Yes,
This has been taken
that has been
note of.
that has been taken.
Child protection. Rules of that.
Okay, because we'll have to have the equipments for video photography and all, everything. There must be officers who will be trained in handling
Correct.
the child, their protection policies include that also.
Lordship. In the policy, it has been taken care of, and in the rules also, it has been incorporated.
Okay,
My lord, if I am permitted to speak, it is in regard with the Honorable Supreme Court order dated 28/8 on a hearing of a case of 3/23, whereby it had directed the secretaries of the Legislative Department to have a meeting with the secretaries of the Women Child Development Department to incorporate the 19(6) of the POCSO Act, which talks about the special juvenile police units, and also incorporate the section 46 of the JJ Act, that is to have the state should have a aftercare plan. So initially we had made a SOP for the in pursuance of this, we had made a SOP, but the legislative department suggested that since we are already forming the rules and it is in the final, so it should be incorporated. So in our draft rule, the rule 25 in collaboration with Rule 46, Act, Section 46 of the JJ Act. We have collaborated that the process is completed and we have sent it for legislative vetting now.
Yes, yes.
Okay.
That we have indicated,
Uh,
annexes C and D, we have indicated that.
Mr. Nath, just that part of our statement, have it recorded in a slip and
Well, if kindly comes to that instruction, page number 2, response page number, the second page of that instruction.
yes, yes.
Malad, we have quoted the Honorable Apex Court's paragraph 44, Roman 1, Malad. We have quoted that paragraph. That relevant portion of that paragraph we have extracted.
Yes.
Then, Malad, after
Okay.
that, to this effect, as directed by the Honorable Apex Court, the Judicial Department convened 2 meetings on 19/10/2024 and 18/11/24. Minutes we have given, Malad.
Okay.
After the issues involved in these meetings, it was decided that since the draft Assam Juvenile Justice Care and Protection Rules 2024 are in the process of being finalized, the Women and Child Development Department will add the relevant provision in the Rule 25 of the draft rules, which
Okay.
correspond to Section 46. We have
Okay,
indicated.
good.
So we have
Gotcha.
corresponded that and included my lord and sent for the vetting of the JJ.
Okay. Please give the name of the officers, we'll record it.
Yes.
Heard so and so.
In fact, in the last order, Lordship has indicated the names,
Same name?
same office.
Okay, same.
Okay.
Senior Government Advocate has produced a copy of instructions dated 17/12/2024, indicating the present status of the juvenile justice boards of 35 districts in the state of Assam. Notification dated 17/12/2024.
It was an instruction to respond. It is para 44.
Relevant as well as minutes of the meeting held in the judicial department. Stop. It is also submitted that the draft child protection policy for the state of Assam, as well as the draft Assam State Juvenile Justice Rules, 2024, has been placed in the cabinet portal and also sent to the judicial department, school education, as well as finance department for their final views. And accordingly, the child protection policy will be placed before the cabinet in its next sitting. First off, it is also submitted that the steps have been taken to incorporate the directions contained in paragraph 44 within bracket Roman 1 small, passed by the Supreme Court of India in wide order dated 28/2024 in suo motu WPC number 3 of 2023. To be incorporated in the draft juvenile justice rules. Stop. Okay. Stop. In view of the prediction that as it is projected that it will take some time to notify the rules as well as the child protection policy, comma, as well as to notify the appointments after the closure of the selection process. Comma, we deem it appropriate to adjourn the matter today. Next, on the next date, the court proposes to also take up the issues of infrastructure relating to the juvenile justice boards functioning in the state of Assam, as well as the condition of the children homes in the state of Assam. Next para, the learned senior government advocate shall inform the court about the status of the issuance of notification for the draft rules of our child protection policy, as well as filling of the vacancies. Next para, list on when
But we request for last week of February. In
That will be too long.
January, so many holidays are there.
Take a chance in the first week of February.
On.
18th, at least exactly 2 months was
okay, February last. Accept your contingent. Do we have to say that in the meantime you will do the in-house what you have to finalize that report also of the conditions? What is it called?
social audit.
Social audit.
Status report, my lord, they are doing the social audit, my lord.
No, but I think that
we can
it
obtain
will
a
be closed by
status.
then. No, status also you'll have to inquire because they have started the work. When they will end, that also is a question.
Definitely. We will get the status report, my lord. If report is there, we'll place it.
Status was mentioned, number 1 to 3, number 4.
To place it if not. the
Social
final.
audit.
My lord,
Huh?
interim report will be able to submit if not the final.
No, whatever, but
Yes,
do some in-house, what you call, processing of the matter. Let's list on. February
27.
last week. Oh, sorry, not 27. Please. Sorry, I'm looking at the wrong calendar.
27
27.
27 is a Thursday, my lord.
Hold on, Chief may fix it on 24th of February.
Or 25th it will be.
25th.
25th
Lodge.
of February. And what is you are also concerned? Please jot in a slip. What are the other points of that note circulated by Mr. Sharma?
My lord, we will prepare another comprehensive note if
Ah.
need be.
Ah.
On what have the steps been taken and what
Yes.
directions have been issued, and we'll come.
What should be the next? We expect that by February, at least one part of this proceeding will be over. We expect that. Then
We will make a
go to
short
the
note
next-
and submit it before your lordship.
No, you can do
The status of this phones.
you can do one thing. We are proposing that note you are proposing,
My lord.
please circulate at least 1 week in advance to Mr. Nath, so that it can be communicated to Dr. Pitileka, and then he'll have the instructions ready.
Very well, my lord. With your lordship's leave, I'll furnish a
It's
an
it's
advance
okay.
copy to Miss Leonard, Mr. Nath, also copy to the Leonard Coastmaster.
Yes. We don't need it because we are not doing, we are not required to do any exercise.
Very well.
We will, he will need. So therefore, since they are working on it, if you give it 1 week in advance, they'll be able to respond to it. Correct?
Very well, my lord.
So we shorten our court time on that.
On city.
But one point, my lord,
अच्छा ये
The officer is
entry
there.
करने लिखे थी वो.
as well as the sitting of the JJB's, my lord, there is a guideline from the High Court
That's
that
what I was saying.
that my lord, from honorable courts.
No, you see, you will have to give us a proposal on the basis of which we will move the on the administrative side.
Because there is a limit of sitting.
Yes, my lord.
And on the basis of that payment can be made. If there is a excess sitting, then again it comes back to us for special
Malad-
circumstances and approval, because ultimately it is a final.
My lord,
So if
I
we can have some leeways in between.
I have
It
a
will be this, but if in certain circumstances it is exceeded, no further direct approval is required, then can be,
Then-
that is permissible.
my lord, lordship may indicate in the order that we want to explore on that my lord, give us liberty to have that, my lord, so that we can initiate and
Oh,
we can
okay. Just say
we can order in-
the learned senior government advocate has submitted that taking into account the pendency of cases before the juvenile justice boards in the state of Assam, the state would also like to explore if sitting of certain JJBs can be increased.
Okay.
Can be increased. Full stop. As per necessity, on case to case basis. Oh, full stop. Full stop. As this is a welcome suggestion, the government may explore the possibility of of rescheduling the sitting of juvenile justice boards in the state of Assam
whenever it is necessary.
Ah.
Whenever it is necessary.
wherever necessary. Okay.
It is a case to case basis. You
Lot-
cannot say that it should be, because two difficulties. One is judicial works are also there. There is the magistrate will have both, and financial implications are also there.
At least, my lord, with this order, my lord, they can explore and they can have
Yes,
they can communicate to the honorable court.
No, that's okay.
Lodge.
Welcome. This
Lodge.
not bad, but since we have also shortage of judicial officers, we also have to think for that. Yes. We taken account your affidavit. We'll take it up on the next day. You have anything to say?
I beg to mention item number 28, my lord. Earlier, my lord, Pranav Sharma appeared in this case. He expired, my lord. Could not trace out the file, my lord. Just some time may be permitted, my lord. And I am also allowed to reconstruct the file from the second copy of the court record.
No, that we can't permit. We'll have to get a certificate copy because under the rules we can't permit that. Item 20, both sides are represented on the prayer made by Learned Counsel for the petitioner. Just after 4 weeks, we are saying.
The date may be fixed, my lord.
We are not fixing a date. After vacation, there's a lot of
After
rush.
vacation.
Yes.
Lordship,
Item number 15. Item number 159. That may be adjourned for the day only, my.
No, 15, 115.
15. Okay, after vacation.
Apply.
15.
15.
Yeah,
Please.
I'd like to mention one item. There is item number 35 of supplementary list. for upgradation, Lordship. This is the person, petitioner is in detention camp and Lordship has fixed it for consideration of bail after receipt of LCR. LCR has been arrived,
Okay, we'll try to take up.
Lordship.
In making a note, we'll try to take up.
Lordship. Obliged.
No, your lordship, I beg to mention item number 2, my lord, madam, the list after vacation any date, my lord,
2 is 2017 matter.
my lord.
I find it very difficult to do. Why in 2017 you are taking an adjournment?
My lord, after vacation any date, my lord.
Okay. After vacation, both sides are represented. Item 2.
Obliged.
And please, your Lordship. Lordship, I beg to mention for listing on motion.
Listing, give it to the court master.
Tomorrow, my lord.
I'm not saying about the date, just give it to them. They will
Because,
make
my lord,
adjustments.
In the tribunal case is fixed on 20, my lord. I am sending it.
They will take a call.
I'm.
Please, Lordship. I beg to mention item number 8, my lord. 8. On behalf of SC Business, my lord. His brother was dead yesterday, my lord.
Huh?
His brother was died yesterday. On behalf of SC
Oh, is
Business.
it? I'm so sorry. Okay. After vacation, item 8.
Hey, please, your lordship, I beg to mention item number 19. Matter will be passable for the day.
Okay, same order, item 19.
Okay, yes.
Please, your lordship, item number 17.
Same. 17.
The lordship, there is an interim which may continue.
You have checked the order. What is the entry order? Have you checked it? Read the order. What is the order? Then tell us whether it needs extension or not.
Lordship, item number 22. My senior counsel is out of registration.
22. Okay, same order. 22.
Lordship, one more item is there, item number 34. Supplementary list.
24.
Supplementary list.
Okay. But why you are getting matters listed by orders and then taking an adjournment?
Sir, due to medical emergency, sir went to Bangalore.
But then you're getting it listed and then you are taking an adjournment. After the issue.
I did mention item number 16 on behalf of M. Hussein. His mother is dead the day after yesterday.
Okay.
After 4 weeks.
After vacation, 16. Okay. Allowed.
May I please, your Lordship? I beg to mention item number 4 for adjournment.
What is
And-
2017 matter?
Yes, your Lordship, I'm on behalf of Advocate B. Islam. His niece is very sick and he had to go out of station ticket. Due to personal difficulty, he could not avail the date.
Okay, after 2 weeks. Okay.
Much obliged.
Please, your Lordship, I beg to mention 14. Lordship, Angus counsel is out of station due to his father's medical emergency. Lordship.
Okay. 14, 2 weeks.
Obliged.
After vacation. Yeah.
Wait, this your lordship. Lordship, I beg to mention item 23, lordship.
23.
Kindly page 1 for the date.
Okay, same order, after vacation.
Lunch stop.
May I please, your Lordship, I beg to mention item number 21, my lord. May be taken up after vacation, my lord.
Okay, same order, 21.
Obliged.
Right, this is lordship. I beg to mention item number 11 and 26. 11 and 26. Lordship,
11 and
26.
26.
May I adjourn this matter for the day, lordship?
Okay, same order.
Last office.
Upgraded item 40.
That will be lot. Lord, IF for rectification of district jurisdiction. District jurisdiction. District jurisdiction. It would, my lord, Baksa instead of Borpeta. Earlier, my lord, it was in Borpeta. After bifurcation, it falls under the Baksa district. Order at page 19, my lord. 8, my lord. Borpeta district, Baksa.
No, that can't be done. Your application is defective. You have not filed an application for impleading. Without the authority being impleaded, we can't give a direction to that, to Baksa. Where is your prayer for impleading?
Where at page, my lord? There are 4, my lord.
No, you are asking us to rectify it. It's not rectification. You will have to implead first. We can't rectify the order when the parties are not there. Your application is defective. File a proper application. You have not paid for impleading.
Yes.
Without impleading, how can we give a direction to an authority? Item 40, as the superintendent of both sides are represented, as the superintendent of police, Baksa is not a respondent in the connected writ petition from our. The matter is adjourned today, so as to enable the council for the applicant to take appropriate steps.
Obliged.
Item 38 with 39. Upgraded.
In item number 38, there is delay of 9 days. My lord.
I appear for respond number 2 and 3, no objection. Apply response.
I am 4, 5, and 7. No objection, my lord. And the same. No objection.
10 days delay.
9 days.
9 days.
Mr. K. N. Chaudhary, Learned Senior Counsel, assisted by Mr. D.J. Das, and counsel for the applicant. Where is that IA?
IA is, my lord,
Oh, acha.
3606 of 20.
3606. By filing this interlocutory, also heard. Mr. R. Dhar, learned, you, for respondent one will be appearing, Mr. Sharma or Mr. Dhar?
Standing counsel, my lord. 4, 5, and 7.
No, one Chief Secretary.
Chief Secretary.
You be, Mr. P. Sharma, additional senior government advocate, appearing for respondent number 1
6.
and 6.
Deputy Commissioner.
1 and 6. You are appearing as a caveator in this matter?
Yeah, 2 and 3.
No, as a
Yes, as a
caveator or
caveator.
as a caveator? Caveat? And Mrs. G. Goswami, then council appearing for respondent numbers
2 and 3.
2 and 3 has appeared as appeared by filing caveat. Also had Mr. Ardhar and its standing counsel for the Department of Tribal
7 and
Affairs,
8, I suppose.
representing respondent numbers 4, 5, 7, and 8. Next paragraph. By filing this interlocutory application, the applicant is seeking condonation of delay of 9 days beyond the period of limitation in filing the connected appeal. The learned additional senior government advocate, learned counsel for the respondent numbers 2 and 3, as well as the learned standing counsel for the Tribal Affairs Department have opposed the prayer on the ground that day-to-day delay is not explained. Next paragraph. Considering the explanation given in paragraph 4 of the application, that there was some delay in obtaining certified copies, and that the applicant's learned counsel took some time to go through the matter, the same is accepted as good and sufficient cause, which has contributed to the delay in filing of this connected appeal. So accordingly, the delay of 9 days is hereby condoned at the condoned without issuance of notice on the respondents, as all the respondents are represented. Next para, the registry shall now register the connected appeal and list the same in the admission column.
Well, there is only 45 days time frame was given by the learned single judge. Can I pray matter may be taken up on Friday if it is not in?
You make a mention tomorrow. Okay. Because it has to go to the registry, it has to be listed. And then say Mrs. G. Goswami, learned counsel for the caveator. The caveator shall be heard in connection with the connected appeal, which by accordingly lists the caveat on the date the connected date petition is listed.
Deeply.
Obliged.
Oh, Mr. Chaudhary, extra copies you'll have to give our read a bill. Oh, I do regular question of your paragraph. No.
Item 1 for motion.
May I please, Your Lordship? Lordship, the opinion of the tribunal is a page number 70. Page number 70. 70, yes. Starts from page number 71. Mr. Sharma, it's a recent judgment where but Mr. G. Bharadwaj, then counsel for the petitioner, also heard. For Union of India, who's there?
Mr. G. Pegu.
Mr. G. Pegul, and it's easy for respondent number 1, Mr. G. Sharma, and it's standing counsel for the FT matters, representing respondent numbers 2, 4,
6.
and 7,
Yes, Lordship.
2, 4, and 7, and Ms. T. Barwal, and standing counsel for the respondent number 3, and Mr. G. Sharma, and an additional senior government advocate appearing for respondent number 6. Next, the respondent number 5 is not a necessary party in this repetition. So accordingly, the name of respondent number 5 is struck off without altering the seriatim of the respondents. Next, filing this repetition under Article 226 of the Constitution of India. Petitioner is sealed. Page 70. Opinion dated 17/5/2024, passed by so-and-so in FT case number so-and-so arising out of IMDT case number so-and-so. Which the petitioner was declared to be a foreigner of post 25/3/1971 stream. Notice to done proposals, call for the records. Extra copies within 2 days. The petitioner shall appear before the Superintendent of Police Border,
Shiran.
within 10 days, below ₹5,000 with conditions and default clause. 10 days time to take bail. Lordship, earlier.
Item 3.
My motion is a supplementary motion. 30.
Supply item 30 for motion.
May I please, Your Lordship?
Yes.
Yes.
Your opinion is of 2020.
Yes, Your Lordship.
We are not giving you interim protection. Your prayer for bail will be considered on receipt of records. But Mr.
A.K. Hajong.
A.K.
Hajong.
Hajong, learned counsel for the petitioner. Also, Mr. G. Pegut, and CGC appearing for respondent number 1, Mr. G. Sharma, and standing counsel for the FT matters representing respondent numbers 2, 4, 6, and 7. Ms. P. Barwa, and standing counsel for respondent number 3.
No, three.
No, you have 3 here. 3, and Mr. P. Sharma, and additional senior government advocate appearing for respondent number 7, 5. Page 32, opinion. 28/8/2020 passed by so-and-so in FT case number so-and-so. Arising out of IMDT case number so-and-so. Where is the petitioner was declared to be a foreigner of post 25 from 1971 stream. Notice extra copies within 2 days for the records. Prayer for bail shall be considered on receipt of tribunal records. Give a date after 4 weeks. Make it returnable date, returnable on so-and-so. We'll give you a date after some time. The prayer for bail shall be considered on receipt of tribunal records.
Supply item 31.
May it please, Your Lordship.
Where is the opinion?
Opinion is at page 32, Your Lordship.
32.
Yes, Your Lordship.
22 opinion.
Hmm?
22 opinion.
22.
2 years delay, yeah.
Same thing, you'll prayer for bail will be considered on receipt of tribunal records.
Lordship.
Mr. S.K. Chatma, Learned Counsel for the petitioner. Mr. G. Pegul and CGC for respondent number 1. Mr. G. Sharma, Learned Standing Counsel for FT matters representing respondent number 2, 4, 6, and 7. Ms. P. Barwa, Standing Counsel for respondent number 3. And Mr. P. Sharma, additional senior government wait for respondent number 5. Yes. Page 32. Opinion dated 8/3/2022, passed by so-and-so in FT case number so-and-so, SP reference case number so-and-so. The petitioner could be a foreigner of post 25 in 1971. Same order. Prayer for bail shall be considered on receipt of ground records. List on so-and-so.
Date দিব স্যার দুইটাতে 22/1 দি দিবা 22/1/25 fixed on 22nd January. Item 32.
May I please, Your Lordship?
Yes.
Impugn order is at page 35A, Lordship. And order dated 39/24, Lord.
24. Okay. Ms. D.
Lord.
Bush, Learned Counsel for the petitioner. Mr. Sharma, we are giving interim protection.
Lordship.
Mr. G. Pego, for respondent number 1. Mr. G. Sharma, Standing Counsel for FT matters, representing respondent number 2, 4, 6, and 7. Ms. P. Barwa, Standing Counsel for respondent number 3, and Mr. P. Sharma, standing additional senior government advocate for respondent number 5.
It's 28.
নতুন কপি তো দিন
ঠিক আছে।
Nine 2024 passed by so in FT7 case number so, reference police and index number so. Declaring the petitioner to be a foreigner post 25 from 1971. Notice extra copies within 2 days. Call for the records. Petitioner shall appear before the Superintendent of Police Border,
Barpeta.
Borpeta, within 10 days. Bail of rupees 5,000. It's one surety. Those same conditions and default clause. 10 days time to take bail.
Yes, Lordship. Deeply advised.
Daily list item 3 for admission. Daily list item 3 for admission.
No representation from the petitioner. All the respondents are represented. It's made clear that if the petitioner remains absent on call on the next date of listing, adverse orders would be passed. List after ensuing winter vacation.
Item 5 for admission.
May I please, your lordships?
Yes, Mr. Day.
My lord, in this case, my lord, the petitioner exhibited 11 documents, 12 documents, my lord. But only 3 documents has been considered. And moreover, my lord, petitioner adduced evidence of DW2. He was cross-examined by the SGB, but his evidence was not discussed at all
Just a moment.
in the judgment.
Just a moment.
My lord. LBO report is also
Just a moment. Just a moment. You have seen your affidavit by respondent number 4.
Lordship,
You read it? No.
no, Lordship.
See paragraph 6A. You see the reference. That's it. Yes.
Lordship. I have seen Lordship, Lordship, there is a LVO report and during LVS inquiry, Lordship, Lordship was absent. And accordingly, that report, accordingly, ERO forwarded the case to the concerned SP Lordship and concerned SP referred the case to the concerned foreigners tribunal Lordship.
But there's no finding recorded.
Hmm.
No suggestion.
In LVS report, Lordship. Yes, Lordship. That was
Neither in the LVS report nor in the Superintendent of Police's reference. It's not there.
regarding ERO's inquiry, Lordship, SP is nothing to do, only to refer the case, Lordship.
No, we understand.
Yes, Lordship.
But even the satisfaction of the SP is not recorded. He is forwarding it. But Superintendent of Police is not a postman.
Yes, Lordship.
Unless the government thinks so. If your government thinks that the Superintendent of Police is a postman, then we have nothing to say. And this opinion is, they are referring to only 3 documents, 4 documents, in fact. Exhibit 1, Exhibit 2, Exhibit 3, and Exhibit 10.
Right.
Where is Exhibit 10, Mr. Dey?
Exhibit 10, my lord. In LCR, my lord, page 50.
50. What is that?
This is the sale deed of 1965 in the name of Turja Bibi.
It's not legible. I have not seen that.
It is not legible, but the original is, my lord, in the same condition. Original is taken away. I am not of the original, but it is the same condition. It is, very difficult to read. Not distinct. So 65 document, my lord. So, my lord, very old documents.
No, you could have, to prove that contents, you could have got a certified copy. Because it is, if it's a registered document, then you have it in the volume book.
My lord.
If you produce an original document which can't be read, it is as good as producing no evidence.
My lord, petitioner belongs to, originally hails from West Bengal. And she married to Dhubri, my lord. After marriage, she come to Assam, my lord. Actually, originally hails from West Bengal, my lord. So
No,
all the documents are from West Bengal.
No, no, this place has a good reputation. The place from where you have come has a very good reputation. All people from West Bengal originate from here only.
That is there. She feels some difficulties to collect the documents, my lord.
Exhibit 10 is not proved. Where is your evidence? Which
My
page?
evidence, my lord. Page 43, my lord. Annexure M.
43.
43.
Exhibit 1 is the GP certificate.
My
His Gaon Panchayat secretary did not come to
Not
prove
come,
it.
not come.
So
my lord.
exhibit 1 gone. Exhibit 2 is certified copy of voter list of
60
1966.
66. My lord.
Here also you don't prove the contents. You just say my father's name is there in exhibit 2.
Exhibit 2.
So what is your
Ex-
father's name? We don't know.
My lord, it is this.
No, you when you prove a document, you prove its contents. So contents of this document is not proved. Then exhibit 3 is a sale deed.
Exhibit 3
Father
is the
purchased
sale.
a plot of land. Which land? Where is the land? 1981 land. It's supposed 71 land. Now exhibit 4 is a ration card.
These things are supposed to
Ration card is post 71 document. After my marriage with Naushad Ali, my name is in so and so.
My lord, most important evidence, my lord, DW2, his younger brother, my lord. Page 46, my lord. He was cross-examined, my lord.
You see, my difficulty starts from order 18 rule 3 capital A. CPC. You must be the best evidence.
Best evidence. DW2 is the
Who is a ration card? So ration card is a post document. Exhibit 5 and 6 are enumeration list. Doesn't help you. Final Khatiyan doesn't help you. You don't even say it's a certified copy. So this no document requiring consideration. Your age is we don't even know your age. Come to page 43. You are hiding your age. And then you are exhibiting documents. When is your first voters list? Your name is entered into which first voters list?
is my lord. 1997, my lord. Raitan Bibi.
You see, while you are giving evidence, you are creating doubt as to your citizenship. You come to page 44, paragraph 9. You make a statement that my father expired before 1995, and after his death, my mother got electoral photo identity card. After death, you got the card. Mother got the card. That means an admission that before that she was not a voter. So you
My
create
lord,
a doubt.
our mother's voter ID has been given, my lord.
We understand.
My lord.
That's why we are asking. Mother got the voter identity card after 95. That means before 95, her own existence in the country is doubtful.
My lord, that cell deed also, though it is not legible, my lord, such 65 land document cell deed is there, my lord, in the name of her
So
mother.
if somebody cannot read it, is as good as proving nothing. You see, I have a document which is of 1903. But it is as good as white paper. Everything has vanished. Now, how do I prove that document? This is the document, 1903. Slip of 1903. Now, this can't be read, it is white. Whatever was written has vanished. Now, how do I prove this document?
Well, some portions are legible there. Some portions are not legible, my lord.
No, but in a sale deed, what do you have to prove? You have to prove title.
Yes.
How do you prove title? By showing the name of the vendor and the purchaser,
Right.
and then the land which is given in the schedule. If that is not there, it's not a sale deed at all. Because if it's a sale deed, it must be a registered document. So then certified copy is available. You'll have to prove the contents anyway. Exhibiting a sale deed does not help you.
My lord,
Contents has to be proved.
I have stated in my petition, my lord, it's only 2 months or 3 months time has been given to produce the documents, but she tried her level best but could not collect the certificate copies, my lord, in time. So she was bound to file the WS and evidence, my lord.
Now, you see, for that we have judicial pronouncements.
And moreover, my lord, 66 voter list, my lord, it is given here, but I have checked in the online, my lord. It is there, my lord, and I have collect the copy also. The whole set of voter list is there. West Bengal website, my lord, in West Bengal website. Voter list is there. Then 66 voter list as it is there, my lord. My lord, the election commission may produce the original, whether document submitted by the petitioner.
It is for you to take steps. They will not produce unless you take steps. In the tribunal,
my
you'll have
lord,
to.
in the
You see, there are so many judicial pronouncements that first you'll have to take steps. If it is not coming, then only you request the tribunal to take steps. You know the law better than me. I've been handling only few cases. You have a large experience.
Lord, I am not so much experienced, my lord. But the thing is that, my lord, she hails from West Bengal, it is correct, and her name also there in the voter list. Parents' name is there in the voter list of 1960. It is also there, my lord. And my lord, this copy, my lord, 66 voter page. Page 17, my lord, of my writ petition. Page 17, my lord. Page 17, that is annexure 2, my lord, and exhibit 2, I originally LCR 42. LCR page number 42. In the right hand side, my lord, officer, signature of the officer receiving the application. He has given this comment, my lord, that the OC election, SDO office, Tufanganj. After verification, he has given this note, my lord. And this entry is correct, my lord.
You are referring to page 17.
17 of my writ petition, my lord.
Yes.
This is the Ismail Mia, my lord, and the right hand side, OC election, given a note. Sheikh Abbas, son of Azimuddin, village Balagoti, was as elector in the year 1966 under
he-
Tufanganj. So, see,
I will tell you something. You see, Mr. Dey, you are referring to page 17, right?
my lord,
This is High Court form number 55M,
my
civil,
lord,
and 30 criminal.
the
Application for information.
information. my
Yes, in Guwahati High Court, under the Civil Code Rules and Orders, we have form number M50. Correct, and that form is required when any information is given about the proceedings in the court. So this High Court form is not a form which can be used by election office.
lord. That is there.
Then. Sorry,
But-
that is judicial form 50, not M. It is J, form J50, under the Civil Code Rules and Orders. So this is rules under the Calcutta High Court, and these rules are applicable only for civil court and criminal court. So this is not even a admissible
And my lord,
document.
page 19, my lord, this is the photostat copy of the voter list, my lord. She produced. Same.
Criminal court की information होता है. Criminal court की information नहीं है. Criminal court नहीं है. अभी civil court का असर है. Civil court is बस the place. Yep. Yes.
My lord, page 19, my
Just
lord.
give me the record for a moment. Daji. Records.
LBO report is totally nil, my lord. Nothing they mentioned. And the date of birth
They
mentioned, my
received
lord,
the notice, lordship,
1966.
Contested the case, lordship. Getting
No,
all
foundation
opportunities
is-
before the
foundation
tribunal
is, my
to
lord,
prove the
is
case,
not-
lordship. And
Without foundation, my lord, this should not be initiated the entire judgment, my lord. In so many cases, my lord, I have gone through. There are side decisions also, my lord. Lordship knows those decisions.
LBO report was not satisfactory, lordship. Then that is why lordship Yarrow referred the matter to concern superintendent of police, lordship.
On the basis of that LBO report, no reference can be made out, my lord.
In para 7, 8, and 9 of the order. Lordship.
I have
Page
submitted,
59.
also given a affidavit in reply of their
You have seen the records.
affidavit,
Have you seen the records?
my lord.
You've seen the records. This exhibit 3 is at page 43 of the records.
43, yes,
Correct.
yes, sir.
You know why we'll have to discard this. You're aware why we will have to discard this exhibit 3? No. You see this 2 rupees or let us say 5
Stamp,
rupees.
stamp duty.
No, no.
But I have,
Anything between 2 rupees to 5 rupees is costing you your citizenship. It's a matter of 2 rupees or 5 rupees. Correct. Now, is it complete? You have given page 1. Is that a complete sale deed?
no, my lord.
No. So there must be 2 or 3 more pages. You save
Yes.
money.
Well, must be. Must be, my lord.
So you save money. It is costing you your citizenship. You attempt to prove a document, then you miserably fail.
My lord, what I am on, my lord. My lord, there are some citations of this honorable courts, my lord,
To us.
Regarding
But
whatever may be the evidentiary value of those documents
yeah,
and oral
yeah.
evidence, my lord.
But
It
you
is
have,
the duty of the learned tribunal to consider and discuss and given reasons on those evidences, my lord. In this case, my lord, the learned tribunal has not discussed.
if a document is inadmissible, why would
Yes.
the court
My
refer
lord,
to it?
My lord, the DW2, my lord, he has categorically stated that a petitioner is his elder sister. And he has given evidence also, his some documents or on behalf of him also. And he was cross-examined, my lord, by the London AGP, but that evidence has not been considered, my lord, at all.
No, I
There are
understand.
some findings should be there, discussion should be there, my lord.
No, you see, it's a case of daily routine. When I'm addressing my esteemed sister, I am addressing her as esteemed sister in front of the entire bar. And it is also being, what you call live, there's a live streaming going on. So the world is, it is before the entire world that I'm calling my esteemed sister with the designation of a sister. Correct.
Link, my lord, I'm
No.
giving evidence in support of documents, my lord.
That's okay, but I'm in a better position because whatever I'm saying is law for the time being, unless set aside by superior court. So you see, merely an oral statement doesn't change the reality. You may be calling your friend sitting behind my friend. He may be your friend, he may be your worst of your enemies. But in court, you refer him to as your friend.
My lord.
So how does it matter? An oral evidence can't create relationship. You see, I have I'm good in telling stories. I'll tell you one. You see, you know about the BMW hit and run case in New Delhi. So a driver who was not present, he came forward and said that I was driving the car. You arrest me. So it is his oral statement. Even a confession, when somebody makes in a criminal case, the court will still scrutinize that confession, how far that confession is voluntary,
My
how
lord,
far
my
that is
lord,
admissible.
He was cross-examined, duly cross-examined by that. My lord. So, my lord, whatever he has given in the evidence, that is to be discussed, either accepted or rejected, whatever it may be the consequence, my lord. That has not been
Right, you
done
are right.
by the learned tribunal.
Evidence of DW2, where is that?
My lord. DW2 in chief, my lord, page 46. And in cross-examination, my lord, page 56.
Yes, Lordship, and that's true, Lordship, but
It has to be remanded back. The court, the tribunal has to consider. Mr. Day is right.
yes, that discussion was not made, Lordship.
Discussion is not made.
But Lordship,
When the exhibits are not discussed,
No.
is right. It has to be remanded back. It will be open to the petitioner to take the defense of ERO. About this verification done by the ERO, the manner which is done. It will be permitted to take that.
Lordship,
We are spending
Regarding
time
how-
on the ground that maybe DW2 was there, but it's not there. Just to go back, it can't be sustained.
otherwise, Lordship, there is no link at all, Lordship.
No, but you definitely don't want us to adjudicate.
Lordship.
You'll have to, we'll have to record your statement that you have no objection if the court takes up the adjudication.
Lordship.
But then we'll be exercising power of the tribunal, which we don't want to.
Only Lordship. On that point, Lordship may remand it, Lordship.
But that
And
also,
regarding-
when the
ERO
verification is not
regarding-
there, he'll be permitted to take it up.
Then Lordship, regarding Yaro's inquiry, Lordship, I have to submit.
You see, there are only one way. If we take up only the ERO verification, then we'll have to allow the repetition and say that if you, if there is a second inquiry against him and if he's found, then you are free to take up. That is the order passed. Because we have no alternative. Then the repetition deserves to be allowed. The ground on which he is declared to be a foreigner is not there. If your authorities by a fresh inquiry finds that this, our order will not be a bar for the registration of a case against the petitioner.
Lordship. Lordship, may-
You have an options choice.
Mhm.
Deep sea or devil. What do you want?
Lordship. Regarding Yaro's inquiry, Lordship,
So we are giving you both options. One side there is a deep sea. One side there is a devil. Now what do you want?
Lordship,
There's a Hindi movie Sholay where everything is decided by a toss. You can go out, have a toss, and come back.
Lordship, can I take time for second half?
Huh?
What is second half?
My lord,
Second.
my case is squarely, my lord, cover up by this
He
decision. by
wants
the-
second half. He wants to go out and have a toss.
Raushana Begum, my lord, and entirely, squarely cover up, my lord.
He has to go out and take a toss. Let him do it.
If Lordship remand the matter on that ground only, Lordship, then I have no objection, Lordship.
No. You see, you can't have a dictating terms.
Yes.
When we pass an order, it will be our order. What we both think here will prevail. We can't give an undertaking that this is the order we are going to pass. That is purely our prerogative. We won't like to share that with you.
Lordship. Lordship.
Okay, 2 o'clock.
Item 6. Item 6.
Is listed next. Advice orders may follow.
Item 7.
May please worship. Income Guzman, my lord. Page 62, my lord. Page 62 is the income order. 62.
Item 7. Shipra Rashid.
Just 2 minutes. Mr. Sharma,
Lordship,
this has to be remanded.
Lordship.
You've seen the records.
No.
Please go through it. This.
Lordship, kindly, Lordship.
Oh, we are more interested in this exhibit A, B, and C. It is down below in the middle, somewhere. You've seen that?
Lordship. Photocopy of LIC insurance policy.
No, that is exhibit A, I think. Next,
BC 71 footer list.
yes, you've seen that.
Lordship.
B, C,
And B
certified copy of voters list.
85.
Correct.
Yes.
Now you come to page 64 of the brief. No, of the brief. Page 64. You're there?
Yes, Lordship.
11 lines from bottom, exhibit A, B, and C are not proof from the originals maintained by the concerned lawful custodians.
Lordship.
This one, we don't know that that's initialized. If the wrong country.
Not proof from the original main.
Original is not required unless the government says so. That you'll have to declare that your officers are dishonest, and therefore, unless the originals are proved, my certified copies issued by the government is not admissible. You just ask the chief secretary to file an affidavit.
Report also there, my lord, from election officer Kolkata.
It's there.
Yes, ma'am. Page
Yes.
60, page 60, my lord, in the regulation.
60.
Yes, my lord.
No, if it is a certified copy, it's not even required.
Also done, my lord. If still petitioner is take 2 steps, my lord. To the election officer Kolkata.
Authentication
Page six-
report.
Page 60 and 60.
This is not referred here.
Yes,
Lordship.
In the opinion, it's not referred.
There are some decision, Lordship, earlier passed by this honorable court, Lordship.
Despite certified copy, originals are to be proved.
No, Lordship, I just,
Sure,
I'm
I'm not aware. Or why don't you settle the things? If the chief secretary gives an affidavit that the government does not trust its officers, therefore certified copy issues by the state government officials are not admissible. Only one affidavit, small affidavit will do.
Lordship.
Ultimately, the Prevention of Corruption Act is meant for government officials. Therefore, there is a presumption that government officials are corrupt. Just a small affidavit, 5-line affidavit. State government does not trust its officers.
Lordship. Our proposition is that Lordship, WPC 4512 of 2016.
What is the name of the party?
4512 Fakhruddin, FA, MD,
Just a moment.
MD.
Is it reported?
Is reported or not, Lordship?
Yes.
It is none.
FA
KHAR,
K
KHAR,
KH.
AR, UDDIN.
One word.
One word, Lordship. Oh. Lordship, may take the help of this copy also, Lordship.
No, this is not a reported case. Yes, please pass it on. What does it say?
Lordship, I'm
pass it
relevant paragraph has been.
Okay, that's right.
Done. Page, page 76, Lordship. Page 76. Page 76, Lordship, of that compilation. Lordship. Lordship.
Copy of a voters list.
Lordship.
Its contents are not required to be proved. This is not a good law.
Yes, Lordship. 2018 4 GLT 395. Burhan Ali versus Union of India.
Now, what does it
Oh.
say?
only a certified copy of voter list or extract thereof would be admissible in evidence. Filing of unsigned, unauthenticated, and uncertified copy of voter list would not be admissible in evidence,
Yes.
Lordship. Yes, Lord.
So this will not, this will not be a good law.
Lordship, Lord.
So if a certified copy is not accepted,
Lordship, in Burhanalis case, Lordship, from para 21.6, Lordship, it was discussed, Lordship. If a procedure relies on a voter list, only a certified copy of such voter list or extract thereof would be admissible in evidence. Filing of an unsigned or unauthenticated or uncertified copy of voter list sought to
please
be relied
give
upon.
that. I'm not able to track it out. Please give that.
It is reported case, Lordship. 21.7, 21.8. Burhanalis reported case, Lordship. 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 But there are some detailed discussions on Lordship. Para 21.7, 21.8, Lordship. 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 91 of 2019 আৰু 170 of 2019 দুইটা পিল এইটো লিখি দিওঁ জানাবলৈ থবলৈ গ'লে এইটো উলিয়াই দিওঁ second. Lordship.
Lordship. We're trying to check this records. I've flipped this record twice over.
Lordship.
I have not found. You see, there is an order of 4/1/2028 allowing the proceeding to take steps. But the steps, I don't find it here. The petition is available.
Lord.
Twice petitions were filed
Lordship.
for steps. And two times these records have come. Verification report has
Yeah.
come twice. Once in January and again in February.
Lordship.
But the summon issued is not available in the record.
Lordship.
Oh, yes, it is available. We found it. Right. Cabinet ने report भी दिले. The report to see boy. It was seen. It was seen. It is seen. ये document to fully this. Certificate copy to fully this. Yes, right. Something is wrong. I'm getting it. These two flags are there. We got that notice. It is available.
Lordship.
Just below the flag is the notice. There's something wrong. I have not been able to follow.
Regarding reports, my lord, page 65, it says this is not the way to prove the original, my lord. Regarding this report, my lord. Nazad, my lord.
Please tell me, I've sent the records. I'll not be able to look at it. Now see, there are two flags, yellow flags.
Yeah.
Correct. First is January 20. It is
Yes.
seen. No, the yellow flag. First
Yes.
yellow flag. This is
Yes.
a forwarding letter.
Yes, Lordship.
Correct. It is said seen. Now, where is the certified copy? Somebody's taken it out. Then there is a second page. This is the summons.
Yes, Lord.
Correct.
Lordship.
There is a postal stamp affixed there.
Yes, Lordship.
Correct.
Go
You see the contents. It says you give a report. Correct.
You report Borpeta.
No, no. In that notice where there is a postal stamp to election office, there is a notice issued. No, no, not Huh. One is to the headmaster, one is to the election officer.
Yes.
You got
the
it?
Page 45 is the petition, Lordship, petition copy.
No, there's a notice also somewhere. 1 or 2 pages here and there. Postal stamps are there. Sorry, postal receipt is there.
Oh.
No, after that. Before that, sorry, before that. Before that.
Yes, Lordship.
Before that, there's one more.
Yes,
There's one more.
I'm getting Lordship.
Yes. This is election office, right?
Yes, Lordship.
Look at the in the middle. It says give a report. There were no witness was called by the tribunal.
Yes, Lordship.
This report has come twice. And twice it is written certified copies are enclosed. Now, where are those certified copies?
Yes, Lordship.
These 2 reports are there. The certified copies somebody is
Yes,
taken out.
yes, Lordship.
But I've not been able to find those.
I think certificate is sent by tribunal, my lord, to the election officer.
No.
This is indicated in the report, my lord. Yes.
It's in the report. Please read that.
Now, with reference to the subject certificate, I have the honor to inform you that the certified copy of electoral roll 1985, 1997, 1971 under Barbota LLC received from your good office is verified at this end and found genuine and correct. Certificate to be sent by tribunal to the, my lord, office of the election officer, my lord.
Okay. Oh, okay.
That is-
Okay. So this why it's not there.
Yes.
This is a good ground. Don't even go to the merits of the matter.
Okay.
Yes, yes, Lordship.
Yes. Yes, evidence is page 46, my lord. Page 46.
46 your written statement.
Evidence, my lord.
And written statement?
Written statement is page 30, 30, my lord.
30. Son of Satish Chandra. The head of the India, sir.
No, no, Lordship. No. Lordship, on answer to questions put by the court. And
So it is in the
Lordship-
back page. In one of the pages, it is in the back page.
Yes, Lordship.
Huh.
In this one, Lordship, page 29,
Huh.
here, he was, procedure was not cross-examined, Lordship. And in order sheet, Lordship, what it was written, 28 2018.
This matter was remanded back by the High Court,
Earlier, it was ex parte order, my lord.
ex parte order.
Ex parte, I need that, my lord. Only some question put by the court, my lord, not by the. my lord.
Yes, Lordship.
Government.
Proceeding is present in person, AGP is absent. Proceeding has been questioned by the court. Official witness DW2 has appeared and adduced evidence and has been discharged after examination. Evidence of the proceeding is concluded and closed.
Okay,
Is proceeded for argument, Lordship.
just shows. আমি যে জলদি উঠে পড়বে আপনাদের পেয়ে আছে হসপিটাল টেস্ট করে ফেলবে
Jatindranath Lordship. Being documents আসলে এখন পড়তে পারে না
হেডমাস্টার was not there students if they don't join did not reach the share join সেমি স্কুলে গিয়েছিল নেটওয়ার্ক প্রোগ্রামে শিক্ষক আছে সিস্টেম এই পড়াইছে
School certificate from the School certificate.
সেমি আপনার 95 और एज हो रही है সেমি अलग अलग सेमी
Certificate.
मुझे यही आपको सही बात मैं एकदम अंडे भी नहीं करते मुझे कोई भैंस को तो मन फिर माफ करते हैं 95 will pass out as F2 split with the person pass out as we are keeping this for the time being.
Yes, Lord.
Pass orders and then hand it over to you.
Lord.
If you're relying on any judgment, please pass it on to the court master. Mr. Ahmed. Nothing to do. We may be 5 minutes late in resuming.
Lord.
We may be 5 minutes late in resuming.
Lord.
Yes, Mr. Atia.
Can maybe maybe pass off
Item
item 10.
10. Just tell the court master.
My lord.
My lord, I have other item, but I will want to leave.
Tell the court master. Report. Record. नहीं record to dictation दिए दिया. हाँ.
Last out.
हाँ.
Yes. Number I think.
हाँ.
Somewhere I get it.
Mr. Ahmed. So far as your first judgment is concerned, Mazibur Mia, that will not be applicable. I'll tell you the reason why. You see, that's why we showed you this record. You took steps to call for the records
Reports.
for the report. Now the report has come. Now you just change the character of this this proceeding. You think that it is a civil case or a criminal case. Correct? You have called for a report. What is this report? Let us say
Authentication report.
authentication report. You, if it is a civil case, you say it's a Latmantal's report. Now, if that has come, will it become evidence merely because it is in court?
Before that, I have produced certified copy, my lord. That is already there. my
No,
lord.
no. You see,
Even then we have called for-
certified copy we have produced.
Yes.
But you have taken you have changed the burden by asking for the report to come. That means there was no necessity when you are proving a certified copy to prove a report.
Yes.
A certified copy cannot be proved by a report. Fundamentally, you are wrong
That is-
when you took steps. Now, please tell me if a report comes to court, does it become evidence? Somebody will have to exhibit it. Has anybody exhibited that? Let us say that the forensic report has come. So what does the IO do? IO says that we have received a forensic report, 293 is an expert, not required to be examined, and therefore I give that evidence. He proves this at exhibit 1.
But report was sent to the court, my lord, not to the
That is your lookout.
address to the court.
No, address to the court because you are asking the court summons. Now, can in respect of summons received, the authority will say that I am giving a copy to X. Receiving summons by a court, he has to give it to the court. What is wrong in that? So therefore, this judgment is not applicable. Because mere production within the meaning of Section 77 is not enough. Because what you did was you shifted the burden on yourself. There was a certified copy, but you took steps. Got a report, but the report was never proved.
Report was not approved.
So, correct. So this judgment doesn't help you. So the only fact is that this is it was not considered. That is the only ground.
Yes, ma'am.
And
And all the judgments are similar in nature, my lord. Then judgment,
Huh?
all judgments are similar in nature, my lord.
So that doesn't apply.
My lord.
Certificate copy produced under 77 is not required to be proved. But if somebody has to still give an evidence that you have done. That is the and you see in a I don't know why this is happening. You see, once let us say that example I gave, allotment report is there. Now, if that allotment report nobody proves, Is the court required to pass an opinion on that? Correct.
Unless it is proved, then no value of that.
So therefore it will not come, because if it's a civil trial or a criminal trial, it does not go to file C1. Any unexhibited document does not go to file C1. So it gets excluded by default. So therefore it doesn't help you. The difficulty is that the lawyers in the trial court, they don't know how to do the trial. That is the difficulty. You can correct me if I'm wrong. If my thinking is wrong, you can correct me still. Heard Mr. H.R. Ahmed, learned counsel for the petitioner. Also heard Mr. G. Pegul, learned CGC, appearing for respondent number 1. Mr. A.I. Ali, learned standing counsel for respondent number 2. Mr. G. Sharma, learned standing counsel for the FT matters, representing respondent numbers 3, 5, and 6. And Mr. H.K. Hazarika, learned government advocate, appearing for respondent number 5. Next one. By filing this writ petition under Article 226 of the Constitution of India, the petitioner has assailed the opinion dated 31/5/2018, page 62, passed by so and so. There are 3 references: FT7 case number so and so, within bracket FT case number so and so, reference FT case number so and so, by which the petitioner was declared to be, by which he was declared to be a she is a lady. She was declared to be a foreigner post 25/3/1971 stream. Pursuant to receipt of summons from the learned tribunal, the petitioner appeared in the proceedings and she had filed a written statement. Along with certain documents. Thereafter, the petitioner had examined herself as DW1, and on issuance of court summons, the headmaster of Uttar Borpeta High School appeared and he was examined as DW2. Full stop. It appears from the record that the government leader for the state was absent, and the DW1 and DW2 responded to the questions put by the tribunal. Next paragraph. The record is revealed that the following documents were exhibited by the petitioner. Now, photocopy of life insurance policy within bracket Exhibit A, photocopy of certified copy of voters list of 1971 within bracket Exhibit B, so that could be proved in original, proved in original Exhibit A, so proved in original Exhibit B, photocopy of certified copy of voter list of 1985, Exhibit C. Proved in original, certified, proved in original, Exhibit C. Photocopy of certified copy of voter list of 1977, proved in original, within bracket Exhibit D. Photocopy of certified copy of voters list of 2010, proved in original, within bracket Exhibit E. Photocopy of the school certificate dated 10/7/2017, approved in original, within bracket Exhibit F. But Exhibit A is also approved in original. It may be mentioned that next para, it may be mentioned that the evidence on affidavit by the petitioner was filed on 3/1/2018, and she was examined by the tribunal on 28/3/2018. The evidence in chief of Abdul Mannan Sikdar, ABDUL MANNAN SIKDAR, DW2, was recorded on 28/3/2018, and on the same day he had answered the queries of the court, questions put by the court, by the tribunal. Full stop. Next para. In the meantime, on a petition filed by the petitioner, by an order dated over in 2018, ordered issuance of notice to call for the issuing authorities of the documents to be proved. Full stop. Such order was repeated on 13/2/2018, 21/2018, and 5/3/2018. And the DW2 appeared on 28/3/2018, and pursuant to the notice issued by the learned tribunal, To the election officer, Barpeta. On the said authority by a letter dated 20 January 2018 within bracket available at page 44 of tribunal's records. Inform the learned tribunal that the certified copy of electoral roll of 1971, 1985 and 1997 under Barpeta LAC received from the tribunal was verified by the election officer from Barpeta and found genuine and correct. Full stop. Similar letter dated 6/2/2018 by the election officer from Barpeta is also available at page 52 of the tribunal's records. Thus, it is seen that the petitioner did not prove the contents of the letter dated 20 January 2018, as well as letter dated 6/2/2018 sent by the election officer, Barpeta. Next paragraph. The tribunal's records further reveal that the photocopies which are referred to as Exhibit A to Exhibit F are all proved in original moreover, from the examination of the DW1 and DW2 by the learned tribunal, no questions were put to doubt any of the documentary exhibits. However, in internal, in the impugned opinion, the learned tribunal had held that Exhibit A, B and C are not proved from the originals maintained with the connected lawful custodians, and therefore the said exhibits were rejected. Full stop. Exhibit D was discarded. Exhibit D and F were discarded as there was a discrepancy in the name of the petitioner, which is mentioned as inverted commas Sipradhar, SIPRADHAR, Sipradhar Dhar, DHAR, inverted comma closed, in Exhibit D, whereas in Exhibit F, her name was written as inverted commas Sipra Rani, next word, third word Dhar, DHAR. And it also had age discrepancy. In view of the contents of Exhibit 8, where the age of petitioner is shown as 22 years, And in Exhibit F, which is the school certificate, her date of birth is shown as 16/1/1969. And therefore, as per the calculation made by the learned tribunal, as per Exhibit D, her year of birth would be 1975, whereas as per Exhibit F, her age would have been 27 years and not 22 years, as indicated in Exhibit D. Full stop. Therefore, all the exhibited documents were found untrustworthy, and therefore the petitioner was declared to be a foreigner, a post 25/3/1971 stream. Next paragraph. As indicated above, the exhibit numbers B, C, and D, B, C, D, and E were certified copies of the voters list of 1971, 1985, 1997, and 2010. Which were proved in original. Full stop. On a perusal of the records, it appears that the said exhibit B, C, D, and E are photocopies of the certified copies of the voters list. Full stop. In the considered opinion of the court, a certified copy of a voters list the voters list is a public record, and a certified copy issued in respect of the voters list squarely false, is squarely covered within the meaning of public document within the meaning of section 74 of the Bharatiya Sakshya Adhiniyam 2023, and and can be proved by producing certified copies thereof within the meaning of section 76 of the Bharatiya Sakshya Adhiniyam 2023. Of the document 74. Before, probably for the 78. It was 78. Which corresponds to section 70 475 of the Evidence Act. Comma, 1872. Full stop. As for full stop. In this regard, we find support from paragraph 21.7 of the decision of this court dated 8/6/2018, passed in WPC 7669 public 2016. Need to find out the name, huh? Name is not there. It is there. Name is Borhan, Borhan Ali, alias Barhan, Barhan, Barhan Ali versus the Union of India and 3 others. These are 8/6/2018. Huh? Pardon me?
Reported case, Lordship.
This is reported?
Reported, Lordship.
Okay. Comma reported in.
I think, Lordship, there it was written, Lordship, in my compilation.
Acha. Ah, yes, you written. 2018 within packet 4, packet goes GLT 392. Okay. Next one. Next one. In light of the above discussions, comma, as the no, not that. The next paragraph. Exhibit as regards Exhibit A, comma, the said document is life insurance policy of Jatindra JTINDRA Nath Dhar, bearing date of commencement of policy as 10 to 1965. Here you go, LIC Act. Life Insurance Corporation of India Act. Mhm. Say Insurance Act. Insurance Act, I. Insurance Act, I. Policy public document. India, that's all. We give that provision. The they said life insurance policy is issued by the Life Insurance Corporation of India, which is a government of India undertaking. Stop. By the said Exhibit A is the policy is also no, is not also contains the insurance stamps which indicate that the same was issued in the name of the person on in whose favor the said policy was made. Post. Therefore, this Jatindranath Dhar is alive or dead?
Dead, man.
He's dead.
Nine.
Under the circumstances, when there was when the correctness of the said Exhibit A was not even questioned by the learned tribunal. Is said revisions could not have been discarded without giving an opportunity to the a reasonable opportunity to the petitioner to prove this a document by calling the authorities. Just next part, ordinarily, such an observation is not is made in under the unique facts of this case, which is not intended to be cited as a precedent, in view of the fact that neither the mode of proof nor the admissibility of the documents were in question when Exhibit A was when the LIC policy was exhibited as Exhibit A. Full stop. Next one. Although the learned standing counsel for the FK matters has made his submission in support of the impugn opinion, but the same is not elaborately discussed in view of the fact that not only the petitioner had proved exhibit B, C, and D, which are B, C, and D, which are the certified copies of the voters lists referred above, comma, but the election officer has also sent to the tribunal the the letter to the effect that the certified copies of electoral roll of 1985, 1997, and 1971, which was sent for verification, was verified and found to be genuine and correct. Full stop. Next program. According to comma, the court is of the considered opinion that the petitioners is required to be given an opportunity of proving exhibit A, B, C, and D. In such, in a manner, on which the petitioner may be so advised. Next one. Accordingly, comma, the objection made by the learned standing person for the FT matters is not sustained. Next, by this, the petition stands allowed by remanding the matter back to the learned member, comma, Foreigners Tribunal, 7th, Dhubri at Bilasipara. Next para. Set aside Kudran. The opinion is set aside and matters demanded back to so. Next para. The petitioner is directed to appear before the learned member, comma, Foreigners Tribunal, 7th, Dhubri at Bilasipara within 30 days from the date of this order. And by producing a certified copy of this order, I must seek further instructions from the said learned tribunal. Next para. It is provided that in the event the petitioner fails to appear within the time allowed, comma, it would be open to the said learned tribunal to treat the petitioner as absent on call and pass ex parte opinion. Next para. Till 30 days from this date, comma, petitioner shall not be arrested and deported. Next, the registry shall send back the records expeditiously. The persistence allowed to the extent as indicated above. Publishing. It will be.
Item 12.
Opinion at page number 74 and lecture 34. Just a moment, there was a prayer for upgradation. Which was the matter? We'll take up those upgraded matters. We were asking for bail, I think. We were asking for bail. The two matters, I think we upgraded. Number 5, my lord. Oh, acha, 5 at 2, huh? 36 also. Huh? 36 also. 36 also, okay. Mr. Chauhan, we are taking up those matters. We are upgraded for bail, constitution of bail. Item, no, Mr. Day's matter. Item 5.
Item number 37.
Just wait.
My lord, in their affidavit in opposition, I have also filed an affidavit in reply, my lord. And the affidavit in reply, my lord, I have annexed a copy of the judgment of this honorable court, my lord.
Regarding lordship,
Regarding lordship. Report of
year
the.
was inquiry lordship. Yes, sir.
Yes, what is the submission?
Lordship, I have provided two judgment, Lordship. One is repetition number 91 of 2019. And another is after that judgment, Lordship, petitioner preferred an appeal, and that appeal was also disposed of on the same footing as earlier disposed of by this honorable court, Lordship. Lordship, first, Lordship will kindly see WBC 91 of 2019, Lordship.
Yes.
Yes, Lordship. From para 7, Lordship, I am reading, Lordship.
Yes.
Mr. D. Burwal Arnett, Standing Council Election Commission of India, has submitted a compilation of documents wherefrom he submits that if the electoral registration officer has any doubt about the citizenship status of a person whose name appears in the draft electoral roll, he gets the matter verified through the local verification officer who makes an on the spot verification, whereafter he submits report. On consideration of such report, if the electoral registration officer has reasonable doubt that the person concerned is not a citizen of India, he forwards the matter to the jurisdictional superintendent of police for getting an opinion from the competent foreigners tribunal after making such person as the voter in the voter list. His further submission is that all the cases of de-voters do not necessarily arise from such an exercise by the electoral registration officer as
Just
Yes,
a
sir.
moment, just a moment. Yes.
His further submission is that all the cases of defaulters do not necessarily arise from such an exercise by electoral registration officer. As per order of this court dated 23/3/2011 passed in WPC number 1334 of 2019, Momeja Khatun versus Union of India, persons whose cases are pending before the Foreigners Tribunal are also marked as defaulters in the voter list. Then Lordship para 8. Mr. You can learn it.
See, we'll cut it short.
Lordship.
By the time you are reading that paragraph, I've read these two judgments. You come to the division bench judgment at para 8.8. Page 7.
Yes,
You got
Lordship.
it?
Yes, Lordship.
Now, the electoral registration officer on receipt of verification reports from the LVO considers the same very satisfied on such report and such other material information as may be available to him about the eligibility of person, he shall allow the name to continue on the roll and include it in the final roll where he is not so satisfied
Yes,
and
Lordship.
has a reasonable doubt about the citizenship of any person. He shall refer it's a doubtful case so and so. Now, where is that satisfaction?
Yes, Lordship, because Lordship, when Lordship LVO visited her house, Lordship, he found absent,
no.
Lordship. That is
That
enough,
is-
Lordship.
No, that is okay.
Yes, Lordship.
If you go to my house, it will be locked now.
Lordship. At least
There must be proof, some proof, my lord.
Because when I'm here,
Can visit it.
in my bag, you will find the key to my house. It is locked.
Huh? LVO report to another.
No, you see, the para 8.8 is that he should record his satisfaction. Where is that
Yes.
satisfaction recorded?
Absent at the time of verification. He must remain absent at the time of verification.
No, that's
Lordship.
okay.
So,
I'm giving you my time. When I go out for my morning walk, my house is locked. Now I'm in court, my house is locked. What is so bad about it?
Lordship, then Lordship, if possible, Lordship, can it be fixed immediately after vacation in?
No, we're disposing it off after hearing, you can't do that. Because you see, the satisfaction is not recorded.
Yes.
So we give you an
He
opportunity.
cannot satisfy Lordship in this report, Lordship. So Lordship, he matter was forwarded.
No, he's not satisfied. Please show the record. Where is he pen down? You see, the difficulty of the government is manifold. Either you do not give him ink in his pen, so he can't write. Or he's a good man, he's trying to save money for the government. He does not write that he has doubt. Both ways the government is benefiting. Ink is being saved. So what is so wrong about it?
Absent at the time of verification.
Huh?
He was absent at the time of verification.
But that's okay.
Yes, sir.
One may be absent,
Yes, sir.
but you have to give a notice. I'm here, I'm telling you, right now, if you go to my house, it is locked.
Yes, sir. So he does not seem satisfied. We should have-
Gate is not locked because there will be a security person. But if you say that we went to the house,
Yes,
house is locked.
He should have made further inquiry or subsequent date or so.
No, you can give a notice that we have come for an inquiry, is not there. Maybe for some reason, you see in a tea garden, have you visited tea gardens?
sir.
In tea gardens, people come out for the work at 5 o'clock,
5 o'clock.
go back at by 5 in the evening. So, for the possibility of house being locked.
They have not mentioned that he was, or someone else is giving or some document. His complaint is specifically written that he's absent at the time of verification.
But he has not visited at all. Where is the proof? Visited. Any witnesses?
ইমানটো কৰিবই কিন্তু মানে আকৌ প্ৰেজেন্ট কৰি দৰকাৰ আছে Lordship, Lordship, remanding, I have no objection, but Lordship, regarding inquiry, Lordship, I think Lordship, fresh inquiry is not required, Lordship, because she is getting enough scope before the tribunal, Lordship.
That the grounds of suspect has to be provided. Now, please provide him with that. If you can provide him now, we'll send him. Even today, that ground is not there. How will he defend himself? In fact, it's required to be quashed. If you find anything else, you initiate a fresh inquiry against him and go ahead. It can't be because that is the law. This is just a division bench judgment of Justice Koteshwar Singh on the point.
My lord, Koteshwar Singh, my lord, that is judgment. Rajabali, my lord. Rajabali. No, no. Yes. Farida. Farida. Sushil Mata. Sushil Mata.
There's also one Santosh Das. Tribunal cannot go beyond the terms of reference.
Lordship, it was distinguished by our High Court, Lordship, in Rukia Begum Borvia's case, Lordship.
Santosh Das.
Yes, Lordship, was on WBC 2279 of 2021, Lordship.
Rukia Begum.
Yes, Lordship. Rukia Begum Borvia.
Just a moment. Rukia spelling will be Rukia.
RUKIA BGUM Borvia BARBHUIYA alias Rukia Begum.
Yes.
Based on some papers.
Yes. Please send the records once again. You know something? You should be करेंगे वैसे लक्ष्मी पूजा लक्ष्मी पूजा Nah, you have your mobile?
Lordship, please.
You check up what is the date of Lokhi Puja in 1997? It was 1410
Lordship.
because in English they write as Kojagora Puja,
Oh,
Yes.
Pujaguri.
Kojagori Puja. So you find out 1997 it was on 14th of October 1997. And this LVO visits the house on Lakhi Puja day. Lakhi Puja should be on holiday.
Yes, Lordship, then Lordship.
Look at this. No, check it up. I may be wrong.
Huh?
I
97.
do some things very impulsively.
Lordship. 30th of October, Lordship.
There is Lakhi Puja on 30th of October 1997.
1997.
But it's showing is New Delhi, India.
No.
No, no.
That is not the same.
Puja Gora Puja is 14th October.
Maybe also. And Assamese there is a difference, so maybe.
Assam is Lakhi Puja because that is they are showing Diwali.
That is Lakshmi Puja.
Lakshmi Puja of the, because Delhi is showing.
Kojagori Puja is. In
Kojagori
Assamese we call it
Yes, Lordship.
that Lakhi Puja. This is it. Mhm. Huh? Right?
Yes, Kojagori Puja is on 14th of October.
14th of October.
I knew it is a-
So this man goes in. Ajit Kumar Sarkar. He is the LVO. My sister is saying that this is not even a case where he writing everything in office because
Yes.
14th office is also closed.
I have categorically stated in my reply that he has not visited Nepal. Yes, my
That's okay.
Hmm.
But you were not so enterprising as we were.
Lordship. I may be wrong, but Lordship, kindly para 13 maybe.
Para 13.
Of the Rukia Begum Bovia.
Rukia Begum.
Yes.
What does it say?
Lordship, from para 12, I am reading Lordship. A reading of the provisions of section 6A makes it explicit that it is a specific provision as to citizenship of persons covered by the Assam Accord, and the core provisions of section 6A are that a person who may have entered the state of Assam from the specified territory prior to 1/1/1966 shall be deemed to be a citizen of India from the first day of January 1966. The further provision is that such persons who entered the state of Assam from the specified territory after 1/1/1966 but before 25/3/1971 from the specified territory and has been detected to be a foreigner shall register himself with the foreigners registering authority of the district concerned, and upon having been registered shall be a debarred of any voting rights for a period of 10 years, but otherwise retaining all such other rights that a citizen of India may be bestowed with under the provisions. And further that upon expiry of the period of 10 years, even the voting rights should be restored back. In case of persons who had entered the state of Assam from the specified territory on or after 25/3/1971, such persons are to be declared as foreigners. In view of the provisions of Section 6A of the Citizenship Act 1955, Clause 2(1) of the Foreigners Tribunal Order 1964 would now have to be understood that once a reference is made, the reference would be whether the person concerned is or is not a foreigner, meaning thereby whether the person concerned is a foreigner who had entered the state of Assam from the specified territory on or after 25/3/1971, or he is a person who belongs to any of the other categories, that is, person who entered the state of Assam from the specified territory
You see,
before.
this issue was, this issue is decided in a manner that irrespective of the reference, whether he or the proceedee has come into India prior to 25/3/1971 or between one,
And
because
62
one.
after 19
No, this
after
is,
1966
after 1961, 1966.
and now.
That is a mere, that's a mere statement. But under 2(1), the reference will always be whether he's a foreigner or not.
Yes.
So irrespective of the date, that is what is decided here. But you come to the paragraph after. Because you see this, in this case, the reference says of the Superintendent of Police, grounds for having a paragraph 11, grounds for having reasonable belief, as noted above in column 7. Column 7, does the person name appear to be in electoral roll so and so? No. So that is the only reason recorded. Can that be a reference?
Remand.
Because you see, you have seen the reference at page 10.
Yes, Lordship. Actually,
The
yes.
person 7 is, does the person's name appear? No.
Inquiry was not conducted by SP Lordship.
No, we understand that,
yes,
but
sir.
you see, this is the reference.
Oh,
In reference, he's not referring to the inquiry by the LVO. He's not referring to it. In LVO, it's not there. He's not referring to it. It's mentioned in column 7. No. No criteria. Work to one. Yes. This lady is now in 2017, her age is 47. So if she's 47 in 2017, she's born in 1991. Nineteen seventy.
Yes.
1970. So in 1971, the name in the voter list will not be there. So what is so bad about it? My name was also not there.
Lordship, remand the matter. Lordship. Lordship.
Then
Lordship, that Rahim Ali judgment, Lordship.
Rahim Ali.
Latest.
Rahim Ali, yes.
Rahim Ali, my lord.
Ah.
Paragraph 35, 36, 37.
Just pass it on, that one.
Grounds 38, my lord. Grounds,
Pass it on.
yes. देख के देखिए इशू विधान को स्टेबल में
Mr. Dey, you give the list of cases you want to file and
Yes,
please give
yes.
us copies also. This 2 days we won't have time to find from the net the copies. If you don't have copies, you get from the bar and give it to us.
My lord,
The judgments in which you are relying.
my lord.
And you are relying on?
Lordship, Rukia Begum Borgia.
I have submitted the list.
And Lordship Samuddin, Lordship. WPC 91 oblique.
Samuddin we have got.
Yes, Lordship. And Rukia Begum Borgia, Lordship. WPC 2279 of 2021. Lordship, if required, Lordship, I can give this Rukia Begum. Yes, Lordship.
Please give it because these 2 days we won't have time to find out for ourselves.
Only I have sent only one.
It's okay. We will share it. 50% I will take, 50% Asset will take. Mr. PC Dey, the counsel for the petitioner, Mr. G. Sharma, G. Pegu, CGC appearing for respondent number 1. Mr. G. Sharma, and standing counsel for the FT matter, representing respondent numbers 2 and 4, and Mr. H. K. Parikar, and government advocate appearing for respondent number 3. So the arguments are concluded, order is reserved. Upgraded matters.
Upgraded item 35.
Page 91 is the opinion, Lordship.
Supplementary lists.
Hey, you're not arrested.
No, I'm in detention.
You're in detention.
Yes, Lordship.
Mr. Sharma,
Lordship.
here it is projected that 6 persons from his family are declared to be Indian
Lordship.
as per opinion dated 21/2/2013. Which page?
One is that page opinion. Page 91 is one opinion. Lordship, this is one of my.
No, 21/2/13. Where you are relying.
21.
You say that 6 persons are your Indian.
Page 74, maybe.
Is 77 maybe, Lordship.
No, this is, what is this, 74?
74, Lordship. This is one of my brother, Abdul Malik, and
That's
5
what you're
others.
asking.
Oh, yes, Lordship. I'm
Then-
sorry.
This is what you're asking.
Page
6 people
70.
are declared to be Indian.
Yes, page 70. And another brother I have stated in my WS, Lordship.
No, whatever is available, you let it remain here. So
But
we
it is-
grant bail to him.
Yes.
Since he's 6 people are in his family. We just wanted you to verify.
Lordship.
Is it same because we have not checked up? We only refer to his pleadings and then
Yes, Lordship.
trying to find out.
Yes, Lordship.
You are satisfied they are his brother?
Lordship.
We are asking you as an officer of the court, you are satisfied that they are brothers?
Yes, Lordship. And otherwise, Lordship will go through kind of 3 exhibits that also. Otherwise also, there are 3 exhibits, Lordship, which the learned tribunal has not considered. These 3 exhibits demonstrate that they are brothers. Because land is inherited from the grandfather to father and now to them.
Their names are there.
Names are there.
We take your word for it.
Page Lordship 30. This is Jamabandi of 3031.
Okay, because of positive time, we are taking your word for it.
Lordship.
Yeah.
Yes, sir.
Heard Mr. Yudatal and counsel for the petitioner. Also heard Mr. G. Pegul and CGC appearing for respondent number 1. Mr. G. Sharma and standing counsel for the FT matters representing respondent numbers 2 and 4. And Mr. H.K. Hazarika, learned government advocate appearing for respondent number 3. I think
Yes,
you are not
Lordship.
there.
Yes.
Huh?
SK Hazarika will appear for respondent number 3, Lordship.
No, is election commission here?
No, Lordship.
No, it's not here.
Not here.
Yeah.
In the cause list, it's ECI. They should have made a party.
Oh, it's okay.
I have given a family tree, lordship, it is there from the family tree. No, no.
You can explain now. Something else.
Sister.
That record may also be confirmed. Is 74 lordship.
No, we are just cross-checking few things. That's right. Next, brother. Pursuant to order dated 18/11/2024, the records of FT case number 4 of 2015, as well as records of FT case number, FT within bracket C, bracket close, case number 826 of 2006 have been received from the Foreigners Tribunal, number 1st, Morigao. So last order. Next, brother. Referring to the set to records, the learned counsel for the petitioner submitted that by opinion dated 21/2013, rendered in FT case number 826 of 2006. One sister and 5 brothers of the petitioner. Para 6 of last order were declared to be Indian.
It should be my brother along with his family member, wife and his children.
Wife
And his children.
Okay. First proceeding, namely Abdul Malik.
Abdul Malik.
A.B. Mohammed MD, Abdul ABDUL, Malik MALEK, and his family members were declared to be Indian. Accordingly, no, not accordingly. Next paragraph, it is submitted that that pursuant to opinion dated 17/1/2023, passed in FT in case number FT 04/2015. The petitioner, namely so-and-so was, alias so-and-so was taken into custody and is now lying in the transit camp, Matia, Goalpara. He was arrested on
31st 5 2024.
31/5/2024. So accordingly, prayer for bail is made. Next para. Prayer for bail is opposed by the learned standing counsel for the FT matters on the ground that after long and arduous effort, arduous effort, the petitioner could be apprehended pursuant to opinion dated 17/1/2023, and therefore his prayer for his bail may not be considered. Next para. Please give the date again. Arrest. Arrest date.
31/5/2024.
How many
She will
days
find-
today? Correctly, yes, on the consideration that the petitioner was arrested on 31/5/2024 and has spent so and so days in custody. And moreover, considering that the perusal of records would, the examination of records would take some time, the court is inclined to release the petitioner, namely so and so, on bail. Providing as follows, 3 conditions. 1 to 3. Next, as a condition of bail, it is provided that the petitioner shall not leave the jurisdiction of Superintendent of Police border. Which place?
It is Morigaon.
Morigaon. So you just add in his submissions, Mr. Sharma.
Lordship.
It is further submitted by referring to statement made in paragraph 6 of the impugned opinion dated 17/1/2023 that there was a foreigners tribunal case against the petitioner's younger brother, Abdul Sattar, who was declared to be a foreigner of post 1971 in the year 2019. And that fact came to the notice of the tribunal only during cross-examination of the petitioner by the learned government leader. And in this regard, it is pointed out that the learned tribunal has referred to the opinion dated 25/4/2019, passed in FT within bracket C, bracket close case number 816 of 2010. Be that as it may. Just remind us of this on the next date. His younger brother was declared to be a foreigner.
Yes, Lordship. That is another writ petition is pending before the honorable.
No, this but
Lordship.
if you don't note, we'll forget on the next
Yes.
day. Next paragraph. As the records are received, this is the matter in the admission column after the ensuing maybe last week of January 2025.
High level.
Was that updated matter?
But I'm sorry, my lord, I was supposed to come in the earlier, my lord.
Just a moment, this updated matter will take it up. Just
No, no, item number 5, my lord, only one point I was supposed to indicate. In item number 5, which was your lordship has already heard. My lord.
just for a moment, because
Yes.
we are running out of time. We'll have to break. break up
Upgrade
for the
item
bench.
36.
FPL. Opinion starting from page number 22, my lord. I was taken into detention on 2/9/24. As of now, my lord, 107 days, my lord. Concluding part of the opinion, my lord, will find at page 25 by this ex parte judgment, my lord.
Mr. Payang, 107 days we are releasing him on bail.
I'm deeply obliged, my lord.
So yes, Tavada, learned counsel for the petitioner. Also had Mr. G. Peg, learned CGC for respondent number 1. Mr. J. Payang, learned standing counsel for the FT matters, representing respondent numbers 2, 3, and 7. And Ms. P. Barwa, learned standing counsel for respondent number 4. And Mr. H. K. Hazarika, learned government advocate, appearing for respondent number 6. Who is number 5? Who's respondent number 5?
NRC, my lord.
I left him.
What's a 5? Mr. Payang. 5 also Mr. Payang. Next, brother. In this will be in IA. This is an IA. Pursuant to order dated 18/11/2024, passed in the connected writ petition, the records of the tribunal is received. First off, the examination of the said records would take some time. Very good. Next, accordingly, the counsel for the petitioners paid for bail by submitting that the petitioner was taken into custody, that pursuant to opinion dated 27/8/2017, passed by the learned member, foreigners tribunal number 7th, Borpeta, 2000, in FT case number 18/2018. The petitioner was taken into custody on 2/9/2024 and has spent about 104 days in custody, and he's presently lodged in transit camp of Matia Gwalpara. Next, learned standing counsel for the FT matters has opposed the prayer for bail on the ground that the notices were duly served to the petitioner, and petitioner contested the claim, but allowed an ex parte order Oh, no.
Did not contest.
Did not appear.
Did not appear.
The notice of duly served, but the petitioner did not appear in the proceedings, and therefore allowed ex parte opinion to come on record. So it is something that, after a lot of effort by the border police and other police agencies, the petitioner could be apprehended. So it is submitted that if granted bail, the petitioner would abscond. Next, be that as it may, bail for these 3 conditions. He'll appear, he got bail before Superintendent of Police, Border, Borpeta. As a condition of bail, it is provided that the petitioner shall not leave the jurisdiction of the SP border Barpeta without prior written intimation.
My
With
lord,
comma, failing which it would be open to the said authority to move this court for cancellation of bail.
I'm deeply obliged, my lord. Opinion
Is-
dated
are you
27,
disposed of?
27/8/19, my lord, not 17.
19. 27/8/19. It is supposed to. The petition, this the matter, this the report which is list. In the last week of January 2025.
I'm
Yes.
deeply obliged.
Another matter,
Item number 37 lordship and 75 years old person in custody lordship.
item number.
I is here. 37 lordship.
Criminal appeal.
Criminal appeal lordship.
This is not foreigner.
Hmm?
Foreigners case.
Not foreigner lordship. It is criminal appeal lordship.
What's here? And we'll take it up. We'll get it listed tomorrow. This matter, because today we will have to rise.
Lordship.
My lord, I have a small submission in item number 5. I want to
Yes.
place a judgment of.
Yes, please.
My lord, my lord, the item number 5, lordship. One small law point, my lord, because, my lord, those, your lordship, suppose that they are probably arguing that, my lord, the ERO report is not correct, my lord, not proper. And the my lord, LVO report is
So
not
that,
proper.
we have ultimately arrived at the conclusion that the report was false. Even if he's not written anything, it was false. The report is dated 14th of October 1997.
But I'm not on that, my lord, it may be false or correct, I'm not on that. My lord, because all those matters were of IMDT, my lord. And the Honorable Apex Court by Sarbananda Sonal has directed all those matters which were pending in the IMDT court. Those has to be transferred to the automatically to the foreigners tribunal. Now, my lord, whether the tribunal have the my lord, right to look, because if there is something, my lord, that has to be reopened, my lord, the Sarbananda Sonal. That point is there, my lord. That's why that point may be kindly looked into. That's point, because, my lord, the Sarbananda Sonal.
Please repeat again.
My lord, Sarbananda Sonal clearly said, my lord, all cases pending before the tribunal under the IMDT Tribunal of 83 shall stand transferred to the tribunal constituted in the Foreigners Act and shall be declared and decided in the manner provided in the Foreigners Act and the rules thereunder. So these cases were pending in the Foreigners Tribunal by not the IMDT tribunals. Those matters has been transferred on the basis of direction of the Honorable Apex Court. Now the tribunal has no jurisdiction to look what is correct or wrong, because it is on the basis of Honorable Supreme Court judgment.
This is something we are we are being
Yes.
We are dealing with day in and day out.
Yes, no, my lord, that
No,
point has to be.
You see, please respond to one question. If the law says that there must be a reference,
Yes,
it must be presupposed that there is a valid reference.
my lord, I understood, my lord. If it is reference, it should be a valid reference. And it was an IMDT reference, my lord. IMDT is not valid. IMDT is not, Supreme Court has said IMDT is not valid. But whatever condition, my lord, even IMDT is not valid. But the old cases, my lord, whether right or wrong, those has to
We
be,
understand.
yes, those has been transferred to the tribunal.
No.
Now, my lord, foreigners tribunal probably may not have the right, whether those are right or wrong.
No,
the
no,
difference.
that's okay. But
In that case, my lord-
now let us suppose, I'm giving an absurd example. I'm good in giving absurd examples. I'm giving you one. Now we say that in a bail order, we reject the bail and say that this man be sent to the jail. Correct. And in the order we write, instead of Mr. A. Das, we write Ms. A. Das. Correct. And we reject the application and we send it. Now, will the jail authority say that, well, I have received the order as Ms. Das, therefore I'll send her to ladies' facilities in the jail. We'll treat him as her, and send him to jail.
That's why, my lord, I'm not on correct. So if
So
there
therefore,
is,
the reference must be a valid reference.
if
If it can be satisfied, The tribunal will not pass a judgment merely that somebody has referred it to us. Supreme Court has transferred it, therefore I'll have to decide it. And how will I decide? I'll answer the reference in the affirmative.
But my submission is that, my lord, if your lordship may hear this issue, because before deciding, because this issue has come, my lord, this point may come sometime, my lord. That's why.
No, definitely
Yes.
you'll get a right to agitate it.
No. No, because my lord,
clarified.
otherwise, my lord, the issue now, my lord, in each and every case, they're coming before this honorable court, arguing that
No,
my lord,
we,
reference
see,
is
we
not
give you
correct.
sufficient, we give the home sufficient opportunity. We could be here, they could watch the proceedings,
Yes.
but they're not showing any interest.
No, no, they'll
And,
come, my lord.
therefore, if you don't give them training, if they don't know how to write these things, ultimately the reference is being made by the Superintendent of Police. We just a few moments back we told, is the Superintendent of Police a postman?
No,
If the government thinks it is a postman, we have got nothing to say.
no,
But when he is
because-
giving a reference, he must also know
Yes,
that what is right, what
he-
is wrong.
He must satisfy with the report of the, my lord.
No, or he can disagree. He says that
Yes.
that nothing is given there, therefore
But my lord,
I suspect him to be a foreigner.
but in case of my lord, ERO's report and my lord, ERO's, my lord, the report, the police has no rule. Police has no, this is decided by this honorable court said you cannot, the police has no rule. He is just.
He cannot record his satisfaction.
Satisfaction.
Can't record.
Yes. It is because ERO is a quasi judicial authority. If ERO sends, my lord, the police has no authority. That is the point in case of ERO.
Look at this record. You satisfy yourself with this record. What has been done? Look at the errors report. You have not seen the errors report. Look at the errors report. You have taken your submission, but
Yes.
we'll have to break. My sister has a single bench.
Yes, yes, yes.
We have noted your submissions, but look in the meantime, you look at the record, Mr. Das.
Yes,
Look at the record.
I have seen the records.
You've seen the record. So where is the reference?
Yes, reference.
It's blank.
No,
As blank as the ink you provide to your officers.
No, my lord, probably, my lord, it is, I'm not able to communicate your lordship. My
No,
lord-
I have understood everything.
No, no. My
Question
lord,
of, you can only make a submission. Whether I'll be convinced or not is
my lord,
in my domain.
here in this case, as if your lordship go through the, my lord, 1997 notification also, the ERO report, my lord, LVO report is not necessary for the purpose of, my lord, purpose
Then
of,
look
my
at
lord-
the SP's report. He
No.
says in paragraph 11, I am satisfied because of paragraph 7. Look at paragraph 7.
Para 7 of the LVO report.
Yes, by this time I have, it's by heart.
My lord, no, my lord, my submission is that the
Look
ERO's
at the
report.
documents three times.
Yes. My lord, in fact, the SP should not have, my lord, because he has no right to do that. My
No,
lord,
that is
the-
okay,
yes.
but he records his satisfaction.
No, he should not record, my lord. That is,
But look at the order.
he should not have, my lord.
Look at the order.
My lord, the, what my submission is, the, my lord, for academic purpose also, if your lordship see, the ERO's report, my lord, in 1997 notification, it is clearly said that ERO report is only for the satisfaction to the ERO, that yes, his name can be continued in the voter list. If, my lord, the LVO report is satisfactory to the ERO, my lord, ERO will not make him, my lord, devoter and send to the foreigners tribunal. If it is not satisfactory to the ERO, then only, my lord, ERO will have no option but to send a matter to the, my lord, foreigners tribunal for this. My lord, so if ERO report is blank, if there is nothing in the, sorry, my lord, if nothing is in the LVO report, if there is nothing in the LVO report, my lord, the ERO has no.
We understand. We understand, you see, but let us see, let us test this argument. Now the police thinks that A has done the crime. He files a charge sheet saying that I have not been able to trace out anything. So, but I suspect him to be a thief. And therefore we are sending him that the court will find out. Because court will give an evidence. In the evidence, it will be found out
No,
whether he is a thief or not.
That is not the way. Here, my lord, ERO doubts. My lord, the system is
You look
ERO
at the
doubt.
document. Where is that doubt? You just tell the court master, I'll get the news. Where is the doubt?
ERO, my lord,
Other
ex-
matters will be left over in either tomorrow or day after tomorrow.
Next.
Make it tomorrow. Day after tomorrow, it's better to have it tomorrow. Any bail matters?
To Lordship, 37, Lordship, item 37.
37 only. That-
Tomorrow, Lordship.
You are. Okay. Oh, okay. Okay, I'm sorry, I missed it out. Tomorrow we are getting it listed. That's fine.
Published, Lordship, published.
What is the offense?
Also 6 is there, Lordship, but Lordship, my submission is I is pending, Lordship, and 75 years old person, Lordship.
Uh,
6 perhaps, Lordship, and
No, it's okay. Well, he's 75. What is the year of offense?
Lordship, 2022, Lordship.
To 2022.
22.
Okay.
Published, Lordship, published.